I found that a really small corner that the government was backed into. Do you agree with that?
Yes, very good point.
Welcome back to Northern Perspective, everybody. As most of you know, if you saw our video this morning, Democracy Watch was in the Supreme Court of Canada today trying to argue that the ethics commissioner should actually be able to be challenged on his ruling outside of the federal government. Why? Because right now it's typically only the prime minister that gets to actually evaluate the ruling. Well, in Justin Trudeau's case with the We Charity scandal, that's kind of a problem. And ironically, a conflict of interest, that he is the one that gets to decide if he is guilty or not based on the findings of the ethics commissioner. Joining us today to talk about what went down in court is the man himself, Duff Conacher from Democracy Watch. Duff, welcome back to Northern Perspective.
Thank you very much.
So this morning, your lawyers and the government lawyers were going at it in front of the entire Supreme Court of Canada, which is a very impressive arena to be in. What went down from your perspective, and how do you feel that the day went?
Overall, I think the day went well. The questioning from the 9 justices, I think all but one of them asked a question of either our lawyers or the government lawyers. I think the questioning was very balanced. They're exploring the issues in this unprecedented case and canvassing the 2 big issues. And so it's always hard to tell from those questions how much they're exploring versus sort of confirming things that they've already reached conclusions on. In my experience in the courts, you can't really get an indication exactly from questioning where the court's going to end up in a ruling, because of course they go back and think about it and try and form a majority ruling out of the 9 justices. So yeah, overall, I think that though the day went well and we got a good reception and good hearing from our arguments.
And I thought it was interesting in hearing the justices ask their questions, because they ended up saying some things while they were asking their questions. And to your point, I don't know how much we can read into it, but what I took away from it was they didn't really understand where the government was coming from in terms of the points, because Democracy Watch's whole argument seems to be that in general, there should be recourse to be able to challenge the conclusions of the ethics commissioner from a judiciary perspective. And the government's position seemed to be very, very narrow in that, well, we're not going to comment on everything else, but this case, they shouldn't be able to challenge that. Is that what you took away from that?
Yes. I mean, both our lawyers and the government lawyers were subjected to a lot of questions, which is good that the justices really engaged with the issues, but it makes it difficult for both sides to present the cases fully because it's limited time, and to get through all of the issues like the lawyers want to present them, because the justices are asking questions. If you look at the written arguments from both our side and the government side, the 2 big issues are the Federal Court of Appeal said that if an ethics commissioner ruling comes out, someone disagrees with it, then they should go to Parliament and essentially appeal it there. But the statutes are very clear, and this is the government's problem today, making the argument. The statutes that govern the Federal Ethics Commission are very clear and say, no, the decision's final, and that Parliament has no oversight over the commissioner when enforcing this federal government ethics law that applies to the Prime Minister, Minister, Cabinet staff, and other Cabinet appointees, senior government officials, essentially, and the heads of all sorts of commissions and regulatory bodies. And then, so for the government to say, well, go into Parliament, that doesn't really make sense. The ethics commissioner position was created to take the decision about whether the ethics law has been violated out of the hands of partisan biased politicians. And the ethics law also applies to all sorts of government officials who aren't in parliament. So are you really going to have a government official that's been found guilty by the ethics commissioner appeal to the House Ethics Committee or the Prime Minister to overturn that ruling? There's nothing in the statutes that allow for that, and it also just isn't something that would happen. And then the second big issue is the federal ethics law and many other laws across Canada, provincial and federal, say that with an agency, board, commission, or tribunal, of which there's about 100 in every province, there's more than 100 federally, they in some of the statutes that govern those agencies, boards, commissions, tribunals, ABCTs as they're called in short, that you can't challenge their rulings for errors of fact or errors of law. And this big issue underlying this case, because the ethics commissioner is protected by this kind of measure, is that legal to do that? Is it legal for Parliament to set up a watchdog and then say that watchdog is the final word on violations of this law, and you can't appeal you can't go to court for judicial review and have the courts rule, even if the watchdog makes huge errors of fact or law? And that's also a difficult case for the government to make. And the justices were questioning them a lot on this, because fundamentally our Constitution and the Constitution of most democracies say you have the government, they act, the legislature passes laws, and then the courts are there to ensure that the laws are constitutional and that actions that government officials take under the laws are legal, and that anyone enforcing the law does so properly. And it's really hard for the government to argue, no, in this case, and generally, the legislature should be able to protect the government from accountability by saying you can't challenge watchdogs and law enforcement agencies even when they don't enforce the law properly. So that's just a summary of where things are at and why there was some skepticism of the justices on the government's arguments.
And for those that may not have watched, and you'll be able to get another chance to watch the second hearing, which is going to be tomorrow as well, and then that'll conclude the 2 days that the Supreme Court is going to spend on this, and then they will deliberate and then come out with a judgment at some point. But the way that it unfolded to what, Duff, you were saying is the lawyers get up and they start making their oral arguments, but the justices can jump in at any time and start asking questions. So especially with the government, I found that they were having a lot of difficulty getting through any of their arguments just because the justices kept jumping in. And this is a lot more difficult than just arguing in front of one judge. You have to argue in front of many judges, so any one of them can jump in at any time. And I also found it was very interesting when the government was making the argument, well, this is appealable. You can appeal to the Prime Minister. And I forget the one justice's name, but she asked the same question that I asked on our video, which was, well, wait a minute. In this case, the ethics commissioner found that the Prime Minister himself, who he was investigating, was cleared of any ethics violation. How do you then appeal to the Prime Minister, who was the person that is actually investigating this? And the government tried to counter that by just saying, oh, well, there's public opinion and people can get upset about it and it can go to the next election. And it didn't seem like the justices were buying that.
No, the situation is the ethics commissioner is enforcing a law. And so if you're saying, well, if you don't like the ruling, then your solution is political, then you're moved from law enforcement, where everything has to be proper and legal and constitutional, and suddenly saying, let's forget all about that and make it a political issue now, where there'll be questions in question period and opposition politicians, if the Prime Minister is let off, opposition members would say, no, I think they're guilty, and we just have this public debate. Or if the Prime Minister was found guilty, you'd have ruling party members saying, oh, the Prime Minister's innocent, or the Prime Minister would say that himself or herself, if we have a female prime minister in the future. And so the whole idea, what the idea of our Constitution is, you don't have debates about legal rulings with regard to whether violations of the law have happened. You don't put those back into the political sphere. If you go anywhere, you go to a court and say, this watchdog, who, in the case of the Ethics Commissioner and all the other democracy watchdogs at the federal level, over lobbying, transparency, spending, this watchdog, handpicked by the Prime Minister, has now ruled on the Prime Minister. And we need to make sure that that ruling, whether it was involving the Prime Minister, another cabinet minister, or any top government official, we need to make sure that ruling was correct. Because this ethics commissioner handpicked by the Prime Minister, maybe the Prime Minister appoints a lapdog who rolls over every time and lets off the Prime Minister or any other top government official when they've clearly done wrong. And then the public's right to a fair and proper ruling is thwarted by this system. And so the public needs to be able to go into court and say, court, please review this and make sure it was actually a reasonable ruling that took into account the facts and the law and reached a conclusion that was reasonable. And that's how our Constitution and our whole system is supposed to work. And the government was essentially saying, no, let's just have politicians debate rulings after they've been made and shut the public out from access to justice and access to the courts.
And the other point that multiple justices brought up, which I thought was a really good one, was when they raised the question of recourse for people that were deputy ministers and not elected officials in government. And for those that may not have seen it, the argument was this. So the question was, if a deputy minister, which is a head of an agency, and they're appointed and they're paid and they're just an employee of the government, they're not elected, and if the ethics commissioner made a ruling on one of them, and as a result, some sort of discipline happened to them, they don't have any recourse when it comes to the ethics commissioner. And the government tried to say, oh no, they do. They can rely on, they were essentially saying they can rely on labor laws, but that doesn't wash because labor laws they don't really intersect with the ethics commissioner on the findings of why said employee was dismissed or not. So I found that a really small corner that the government was backed into. Do you agree with that?
Yes, very good point. And again, just to remind people, this law is a conflict of interest law to prevent not just 40 politicians, the prime minister, cabinet ministers, junior cabinet ministers, which are called parliamentary secretaries, not just those 40 or so people, but also almost 3,000 other top government officials. And it's there to ensure that they do not participate in decisions. It has huge loopholes in the law. We won't go into that, but generally the idea is they're not supposed to be participating in decisions where they have a conflict of interest. And it's a very weakly defined standard for conflict of interest in the law, just to mention that, but at least it's there. And so, if the ethics commissioner found one of these officials, not someone in the public eye, an obscure associate deputy minister or the head of one of the 140 or so agencies, boards, and commissions out there that are headed by cabinet appointees. If one of those people, whether they were found guilty or not guilty, they really would have no recourse. Let's say they're found guilty and the prime minister says, okay, we now have cause to fire you and we're firing you. They could challenge that firing, but they wouldn't be able to challenge the ruling that the firing was based on if the government, that's what the government was arguing today, because you'd have to challenge that ruling directly. Challenging the firing is challenging a firing process and whether it was done fairly. And what the government would say in that case is, well, it was done fairly. We had a ruling saying they violated a fundamental democratic good government law, the Conflict of Interest Act, and that was cause enough to fire them. The only way they could win that is to also challenge the ethics commissioner's ruling and have it overturned. So they need that avenue. And the government is saying, no, they should be shut out from doing that. Instead should go to the parliament and somehow appeal that ruling. Even though, again, The laws that establish the Conflict of Interest Ethics Commissioner say very clearly that Parliament has no role at all in reviewing any of the Ethics Commissioner's rulings. So that's if they are found guilty. Let's say this Associate Deputy Minister is found guilty, but there is no punishment, right? So they're just found guilty and the Prime Minister decides not to fire them. They still have this ruling that they violated the law. And the government, even more clearly, is saying they shouldn't be allowed to challenge that ruling in court. And they wouldn't be able to challenge it because they hadn't been disciplined at all, fired or anything. So they just have to live with a ruling that they disagree with, and they're not allowed to go to court and challenge it. It doesn't really make sense. And so that's why you saw the skepticism from the justices. This law does not just apply to the Prime Minister, who could essentially overturn the ruling himself by ignoring it. It applies to 3,000 top government officials. And of course, we're in this very important area of government integrity. That's what this law is all about. And so you can't overlook that we need to get this right? If someone has done wrong, then they should be found in violation. It shouldn't be covered up by the Ethics Commissioner, and that shouldn't be allowed to stand. And if someone is found guilty and shouldn't have been, they should also have recourse. So we'll see where the court goes with their ruling on it. Tomorrow's hearing, there's 15 interveners, 4 attorney generals from the provinces, who are all arguing essentially the government should be allowed to limit the court's review of these kind of decisions by barring review for errors of fact or law or other grounds. And then the rest of the interveners, actually 9 out of 10 of them are citizen groups who do the kind of cases that Democracy Watch does and want these barriers removed to court review of administrative decisions. And one of the interveners is the Ombudsman and Public Integrity Commissioner in Saskatchewan. So it was actually one of these kind of tribunals. And they're arguing for for the court to go down the middle and allow some reviews and bar other reviews. So we'll see the hearing tomorrow. And then, as you mentioned, the ruling will come a few months from now as the Supreme Court discusses it and tries to have a majority agree on a ruling on these 2 big issues.
And just briefly touching on the initial difficulty that Democracy Watch even had bringing forth this case, going back to, I believe it was 2021, where the Minister of Justice, aka the Attorney General of Canada, was blocking this from even getting to the Federal Court of Appeal. Given how the government performed today, does that provide some clarity as to why they were trying to block it to you, do you think?
Yes, they've been raising the same arguments all the way through. They brought a motion for the court just to throw the case out initially, said we didn't have standing, again, which fits because they're saying the ethics commissioner is under Parliament, so only parliamentarians would be able to bring this kind of case. We won public interest standing at the court. And then we ended up being this test case for this issue of whether these measures in the ethics law that say you can't challenge the ethics commissioner's rulings for errors of fact or law, which is exactly what our case was doing, that those measures in the ethics law prohibit us from bringing the case to court and having the court review it. And that's how we've ended up in the Supreme Court on this very fundamental issue of these kind of provisions, which are called partial privative clauses. These are the ones that are barriers and say the courts can't review decisions like of commissioners like the ethics commissioner on certain grounds. What it raises more, the fact that we're now almost 5 years into this process since we first launched the case, is a bigger issue that Democracy Watch also has been advocating on for now 20 years. And we've taken cases to court as well, which is we need really good frontline people in these agencies, boards, commissions, and tribunals in every area. The area we're concerned about are the ones that enforce democratic good government laws. We can't, and the solution to getting good people is you can't have politicians choosing their own watchdogs. It's a conflict of interest. And ironically, despite that conflict of interest, the Prime Minister chose the ethics commissioner who issued this ruling. And the ethics commissioner's office was investigating the Prime Minister at the time. And so when you have that allowed, you have an incentive for the politicians, government officials, to choose people that are not going to enforce the law properly, that are going to let off and cover up wrongdoing. And it's just very dangerous to our democracy. And so, really, a fundamental change that's needed that I think would prevent cases like this in the future is we need a merit-based, fully independent process for choosing these key watchdogs, not just in this area, but in all the other areas where agencies, boards, commissions, tribunals are enforcing really key laws, like the Human Rights Commission and many of the others, where fundamental rights are at issue, and fundamental principles of democracy are at issue. Those watchdogs should not be chosen by the politicians and government officials that they're watching over. And so we need to change the appointment process and make it much more independent, so that we get good people in those positions who are serious about their jobs, don't feel like they owe a politician because the politician gave them the job, and instead do their job properly and as a public watchdog, a watchdog for the public interest, as opposed to a lapdog for the ruling party politicians in cabinet and prime minister. And the same goes at the provincial level. We need much more independent appointment processes for all the key democracy watchdogs, over spending, transparency, ethics, lobbying, and every other whistleblower protection and every other aspect of democratic good government.
Well, and this is why the level of trust in government and politicians has been declining, over the course of the last 20 years or so, because more and more power is being consolidated within the Prime Minister's office, and multiple civic advocacy groups agree on that, including Democracy Watch. So if to the argument, if the politicians are going to be appointing these people to do their bidding, well, there needs to be a check and balance on that. And, what better place than the courts, right?
Yeah, indeed. We need the judicial appointment process as well, though, made more independent. It's very partisan and political in some provinces, and the federal level. And Democracy Watch challenged that and has challenged that in court in the past, and is planning some challenges in the future as well. You need to have fully independent, fully empowered watchdogs over government officials and politicians. That's how you stop abuses of power. And we do not have the independence needed in the appointment processes for this. And so you just really can't have this closed circle that lacks accountability in every way, that shuts out the public from holding the officials, the watchdogs, the politicians, who we all pay for, shuts us out from being able to hold them accountable when they act in wrongful ways and unlawful ways. And so that was what's fundamentally at issue in this case, and allowing the courts to judicially review them will help a lot, because then all of them will know, if I do this wrong, if I ignore the facts, I ignore the law when I'm ruling on this situation, I could end up in court. But again, just to highlight, we're ending up in court 5 years later. If we have to win at the Supreme Court, then we'll go back to the Federal Court of Appeal, where they will look at the Ethics Commissioner's ruling on Trudeau in the We Charity scandal. They'll rule on it. Maybe they will say the commissioner was right. Then we'll have to go back and apply to the Supreme Court. And we'll be 7 or 8 years later with Prime Minister Trudeau long gone out of office. And as a result, he's really let off from the wrongdoing, even if we win in the end. We need good frontline people doing these jobs, so that, and as a result, they can't be chosen by the politicians they're watching over, because the politicians will always look for someone who won't do the job properly, who will cover up wrongdoing, who will ignore the law and give them a break. And so that's really a key part of the solution, is ensuring that the appointment process changes for these and many other of these so-called administrative tribunal decision makers.
Well, the good news is that, potential good news is if and when the Conservatives do form government, they have committed to significantly increasing the penalties of breaking any of the ethics laws, which I think Canadians would be welcome to see instead of a $200 fine and a slap on the wrist. And I hope that they will also be open to changing the conflict of interest laws based on all of the loopholes that groups like yours have brought forward. And we've seen these loopholes play out in real time with Prime Minister Mark Carney and his conflicts of interest. But I'm optimistic. I'm optimistic about this case. I think I know we can't read between the lines, but I'm just going to be hopeful based on the questions that I heard yesterday. But we will be watching tomorrow, and we wish you and the team good luck and the interveners in their arguments, and hopefully this leads to a positive result so we can get this We Charity scandal finally back into the arena where it belongs, which is a court of law to decide whether or not the ethics commissioner was actually correct in his ruling, which I think the vast majority of people that know about it believe that he was absolutely not.
Yeah, it's the one good aspect of this system is the prime minister or a cabinet minister or government official may deny wrongdoing, and the ethics commissioner may roll over because the ethics commissioner is handed the job by the prime minister and roll over and protect the prime minister and say there was no wrongdoing. But there's still public accountability because the public can look at a situation and say, that smells. And I don't care what anyone says inside Ottawa, it smells. And so there is still that political cost to the prime minister and other government officials enacting these ways that are so clearly wrong. But it would be nice that there actually is legal accountability and a finding of violation, because that just makes it very clear to everyone that there was wrongdoing. It's not a matter of opinion. We'll see where this goes. And we've talked before, and we'll hopefully talk again about this whole review of the ethics law that's happening. And as you mentioned, Conservatives, Bloc MPs as well, interested in closing some of the loopholes, strengthening enforcement and penalties. Of course, all of that depends, if they're able to do that, on remaining a minority government. And that could change between now and when Parliament opens in a couple of weeks, or after that. If the Liberals get a majority, you'll see, unfortunately, all of these kind of investigations shelved, as they'll have a majority in every committee, and they'll thwart any attempt to investigate Prime Minister Carney or any other government official. So hopefully it will remain a minority government. I'm actually calling on Liberal MPs to act on principle if party switching ends up giving the Liberals a majority, that some Liberal MPs should act on principle and leave the Liberal caucus and sit as independents to deny that majority, because the majority should not happen through party switching. It's just so dishonest and unethical.